suara. Ada nggak? Ini doang. Halo, Bu.
Good afternoon,
His Excellency the Dean of the Faculty of Law, University of Pajajaran, Mr. Idris SHMA. His Excellency Mr. Sergei Rosomakhov as the trade representative of the Russian Federation in the Republic of Indonesia. Respectable representative from Bursa Hukum, Ms. Doli Dwi Jatmiko Latabulo, SOS MMICOM, and the Honorable Mr. and Mrs. Speakers, and the distinguished participants. My name is Naila Matullah, as the moderator in this event, and I would like to extend a very warm welcome to all of you to this international webinar pertaining to the comparison of the enforcement arbitration awards perspectives from Russia, Honduras, and Indonesia. This event is organized by Bursa Hukum and supported by the Faculty of Law, University of Pajajaran, the LBM Lawyers, Russian Embassy of Indonesia, and the Prospera Arbitration Center from Honduras. We shall have the outstanding presentations from our prominent presenters, whom I believe shall enrich our insights and knowledge regarding the arbitration laws from various countries. We would like to also kindly request to all of the participants to turn their video on. To begin this event, we are pleased to have Mr. Dr. Idris SHMA as the Dean of the Faculty of Law, University of Pajajaran, to deliver his opening remarks. Mr. Idris, the time is yours.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, good afternoon and welcome to international webinar on enforcement of International Arbitral Award perspective from Russia, Honduras, might be Spain, and of course Indonesia. Ladies and gentlemen, the world is not unlimited by any activities or so-called what we mention borderless society. By many activities, business, trade, investment, and also sport, IT, crime, cybercrime, and of course, and others. We are now facing complicated international problem, but we have also applicable solution, such as a UN Convention on the Regulation of Enforcement of Foreign Arbitral Award 1958, or we call New York Convention. And of course, many countries are the members of the convention, including Indonesia. I don't know exactly Russia, or might be the speaker will explain later. And also, we have relevant law that it's operational. The convention has already ratified by Indonesia by the presidential decree number 34 of 1981. While Indonesia has already the law of number 30 of 1999 regarding arbitration and ADR, alternative dispute resolution, which recognizes arbitration organized by ad hoc tribunal and also arbitration under the auspice of foreign institution. Indonesia also is contract state to the 1965 Convention on the settlement of investment dispute between state and national of other state, exit convention, by law number 5 of 1968 regarding settlement of dispute between state and national of other state on the capital investment. The arbitration law also implement enforcement of the UN Convention on the Recognition and Enforcement of Foreign Arbitral, law number 30 of 1999. Of course, the rule this distinguished arbitral award based on the seat of arbitration, that is enforcement proceeding relating domestic award or international award. So enforcement problem is one question is problematic, or of course many problem. So the question is, yeah, is international arbitration award applied by state in that one jurisdiction or national court? Because what I mentioned before, that now is borderless, now is border society. So what happened in one state relating to the law also will give effect to other state. So that's my question. What is the status of arbitration foreign arbitration award? Can be applied by many countries or based on the principle of policy or any other relevant with the case. And therefore, I would like to say welcome again and thanks very much, because now in front of us we have a lot of experts. Yeah. So welcome to international webinar, and we are very happy of because of many experts are here. Therefore, I would like to say welcome again and many thanks to the honorable. First, Irina Strakoskaya, lawyer at Tensor Consulting Group. Is good afternoon. Maybe in your country is morning or a night. Yeah. Anyway, thank for Irina. Yeah. The second is Sergey Rosomakov. Yeah, thank you, Irina. Good afternoon. Sergey Rosomakov, trade representative of the Russian Federation in the Republic of Indonesia. Of course, you are maybe here in Indonesia. Selamat siang, Sergey Rosomakov. The third is Maria Asbi Dominic, LLB, LLM, legal at Paris, Lorca, Spain. Oh, Spain, welcome to Real Madrid and Barcelona, yeah, the most popular in football, yeah, Spain. The fourth is Ricardo Alessandro Gonzalez, Deputy Chief of Legal Officer at Rospera Arbitration Center, Honduras. The fifth is Doli Dwi Jatmiko, SOS MMM-Ecom, Director of Communication, Bursa Hukum and Bursa Legal, and also lecturer of Business Communication, faculty at Calbis Institute. The sixth is Jeffrey Santoso, SHLM, partner at LBM, lawyer Indonesia. The seventh is my colleague, yeah, she is expert in arbitration law, is Dr. Prita Amalia. Hello, Dr. Prita. Good afternoon. Selamat siang.
Thank you.
Thanks your participation, and you are very good organizer in this case. Yeah. So Dr. Prita Amalia is my colleague, lecturer, international commercial arbitration, and ESDS, and of course she is my colleague, lecturer at the Faculty of Law, University of Pajajaran. Ladies and gentlemen, and also distinguished all participants and happy audience. So again, welcome to international seminar, international webinar. Good luck and of course successful. Hopefully this seminar, this webinar might be followed by collaboration, yeah, between us, between Pajajaran University, and also between Pajajaran and other country, yeah, because we are very care about the how to settle international dispute in terms of arbitration, in terms of enforcement and others. And of course, the material or the result of the seminar might be shared into stakeholders, yeah, academy, leisure, and of course, and also especially for my student, yeah, because my student they are very smart, and of course they are very humble to get new knowledge for their assignment. So again, thank you very much for the organization and success and selamat siang, sukses selalu, terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Dr. Idris HMA, for such delightful opening remarks. We do concede that the interesting questions is regarding the status of the foreign arbitration awards in domestic perspectives. We hope we can discuss it further in this event.
But let me to leave because I have other meeting with other. Okay, thank you. Good luck.
Thank you, Mr. Idris. We are also honored to have Mr. Sergei Rosomachov as the trade representative of the Russian Federation in the Republic of Indonesia. To open this event, Mr. Sergei, please.
Okay, selamat siang. Dear Pak Idris, ladies and gentlemen, thank you very much for the opportunity to address your webinar on issues with procedures and arbitration Russia. Our organization, Russian Trade Representation, is a diplomatic mission. We are part of Russian diplomatic mission, and we are in charge for trade and economic cooperation between Russia and Indonesia. And of course, arbitration issues is very important for us, for Russian companies doing business with Indonesian counterparts. And I do hope this webinar will help business people, Indonesian partners to understand better arbitration procedures and practice in the Russian community. First of all, regarding legal framework, there is a federal law for international commercial arbitration of 1993. That law was amended in 2017. This governs international commercial arbitration while the anti-trust law in international commercial arbitration law. Russian law adopted the requirement that in order arbitration, any arbitral institutions, including those located abroad, must obtain licenses from the Russian Ministry of Justice. Only arbitration administered by licensed arbitral institutions are considered institutional arbitrations for the purposes of the Russian arbitration law. The leading Russian arbitration institution is the International Commercial Arbitration Court at the Russian Chamber of Commerce and Industry. Besides that, there are some other
Tutup sama nenek ke TV. Oh, saya makan lagi. Bisa makannya.
arbitration institutions. The Maritime Arbitration Commission of the Russian Chamber of Commerce and Industry, the Arbitration Center at the Russian Union of Industrialists and Entrepreneurs, the Russian Arbitration Center at the Russian Institute of Modern Arbitration, and the National Center of Sports Arbitration at the Sports Arbitration Chamber. As regards foreign licensed arbitral institutions, the Hong Kong International Arbitration Center and Vienna International Arbitral Center have obtained the status of permanent arbitral institutions and are able to administer international arbitrations seated in Russia. Russia is a party of the New York Convention and has been one of the regional member states since 1958, then as USSR. According to the law of 1993, any disputes of commercial nature involving a foreign party, as well as commercial disputes where at least one party is a Russian company with foreign investments, can be referred to international commercial arbitration. The law doesn't specify the required level of foreign participation in a Russian company with foreign investments for a dispute to be eligible for international arbitration. In practice, even a nominal foreign investment in a Russian company can satisfy this requirement. It is worth noting that commercial disputes arising out of insolvency, registration, reorganization, and liquidation, etc., do not qualify as arbitrable disputes. The law sets out a mandatory provision as to the written form of the arbitration agreement. Exchange of letters, faxes, emails, and other means also qualify as evidence of a written arbitration agreement. However, submission by the parties to a dispute of their statements of claim and response without further challenge of the jurisdiction of the arbitral tribunal may effectively evidence the existence of an agreement to arbitrate even without any written document at hand. A careful drafting of international arbitration clauses is imperative in Russia, as is true for many other jurisdictions. As regards enforcement of foreign arbitral awards, the legal basis for enforcement of foreign arbitral awards in Russia is the New York Convention. Russia took a very active role in the drafting of the convention and had already ratified it by 1916. However, there was not a single reported instance of court enforcement of foreign arbitral awards under the New York Convention in Russia until 1992. It could be due to the fact that parties were state enterprises and were bound to voluntarily comply with arbitral awards. Nowadays, Russian courts consider from 50 to 70 applications to gain recognition and enforcement of foreign arbitral awards under the New York Convention annually. Presumably, the rest of the awards are complied with voluntarily arbitral award voluntarily. When handling a situation of enforcement of foreign arbitral award in Russia, one must contemplate an assistance of experienced local counsel at the very outset of the proceedings, because this situation requires a diligent approach and knowledge of all formal and procedural requirements of the state courts. According to the statistics of major Russian arbitral institutions, the International Commercial Arbitration Court at the Russian Chamber of Commerce and Industry, most arbitrations, about 75%, arose out of supply agreements. The next most frequent types of contracts that formed the basis for arbitrations were services contracts, and lease contracts. Russian court proceedings are quite efficient in terms of time and costs. Many disputes are referred for resolution to the Russian state courts, particularly where the amounts at stake are not substantial. However, commercial arbitration is common, especially in larger and more complicated cases, as well as in international contracts. The principal advantages of arbitration in Russia are generally the same as in most other jurisdictions. I mean, neutrality of the forum, the confidentiality of the proceedings, etc., etc. As regards our bilateral trade and our bilateral trade practice, many Russian companies dealing with Indonesian counterparts prefer to apply to Singapore International Arbitration Center, SIAC, or Stockholm Arbitration. As regards Indonesian Badan Arbitrasi Nasional Indonesia, BANI Arbitration Center, unfortunately, not many Russian companies and organizations quite well got enough information regarding this arbitration court in Indonesia, and I believe that this webinar will help us to get more information about procedure of BANI Arbitration Center and etc., etc. In conclusion, I would like to once again wish all the success to participants of this webinar, and do hope that once again it will help to promote our trade and economic cooperation. Thank you very much. Terima kasih banyak.
Thank you and selamat siang too, Mr. Sergey, for your fascinating welcoming remarks and a brief summary of the Russian arbitration law. We hope this event will further expand the investment law between Indonesia and Russia or any other foreign countries. Further, we would like to welcome Mrs. Doli Dwi Jatmiko Latabulo, SSOS, MMMICOM, as the Brand Director Communication at Bursa Hukum and Bursa Legal. Mrs. Doli, please.
Thank you, Naila. Good afternoon, everyone. It is my pleasure to welcome you all from various countries to Bursa Hukum International webinar event today. Enforcement of International Arbitration Awards, Perspective from Russia, Honduras, and Indonesia. Thank you to all our honored speakers from Indonesia, Russia, and Honduras for making your time to contribute in this webinar event. And for all the participants, thank you for being so enthusiastic to attend this webinar that the organizer team had to sort and prioritize for the first 80 registrants only to join, considering the efficiency in our webinar. Actually, until this afternoon, there are lots of participants who are willing to join this webinar event. Hopefully, in the next batches, we can get more people to join and contribute in this webinar event. Well, no one size fits all, and each country applies a different way to deal with the arbitration cases for sure. That's why in this afternoon, in collaboration between Bursa Hukum, Bursa Legal, Pajajaran University, the law faculty, and supported by LBM lawyers, through virtual, we bring together all the experts to share their valuable experiences, their knowledge in their countries that will inspire us and reach our insights and sharpen our strategical thinking in the arbitration issues. And I do really believe that it can broaden our perspectives to give the best advices, to give the best solution in arbitration issues. I do hope that all of you, all the participants will take the advantage to come up with valuable recommendations and conclusions that will beneficial to your works and to your country. Once again, thank you so much. Thank you, Mr. Sergey. Thank you, Mrs. Prita, Irina, Mrs. Indriwati, and sorry, Mr. Idris. Mr. Idris from Pajajaran University. And so again, enjoy the webinar event, and thank you so much. I wish everyone a successful, safe, and fruitful webinar. Thank you.
Thank you very much, Mrs. Dolly. It was such a lovely remarks. We would like to proceed to our prominent speakers from various countries, from Russia, Honduras, and Indonesia. The participants are welcome to inquire anything revolving around the presentation in the question and answer session, which will begin after all the speakers have concluded their presentation. We also would like to announce that there will be 2 best participants for today's event. Therefore, we expect participants' cooperation to be active and to be involved. However, we would like to apologize that the Spain's representative will not be attending to this event due to the personal matters. Nonetheless, we will still assure that this event will still be beneficial towards all of us. Without further ado, we would like to welcome the first presenting speakers for today's event, Ms. Irina Strelkovskaya, LLM, as the junior lawyer at Tensor Consulting Group, Russia. She's really passionate regarding the arbitration laws, international private law, and commercial laws in Russia. And Ms. Irina will briefly share to us in regards to the enforcement of the arbitration awards in Russia. Ms. Irina, the time is yours.
Yeah, good afternoon. Thank you so much for this invitation. I'm really glad to be here today and talk about enforcement in Russia. And I hope you'll hear me well. Naila, I hope you will write me if I will have some technical issues. As it was said, my name is Irina Strelkovskaya, and I obtained my bachelor degree in Moscow in Russia, and last year I spent in Penn State Law School in the US and obtained my LLM program, and my concentration was in particular international arbitration. So today I will talk about enforcement of foreign arbitral awards in Russia. And thank you so much for Sergey Rosomachov, who gave you overview about Russian legislation. I will try to not repeat some provisions and give you more statistics. So on the next slide, as you can see, Russia is a successor of the USSR, and it is a part of the United Nations Conventions on the Recognition and Enforcement of Foreign Arbitral Awards, and also the procedure of the recognition and enforcement of foreign arbitral awards is laid out in detail in the Russian national legislation. And you can see 2 main laws in the next slide. It's the law on international commercial arbitration and the arbitrage commercial procedure code. Moreover, it should be mentioned that Russia is a model law jurisdiction. That means that the law on international commercial arbitration is based on the UNCITRAL model law. And it regulates like most aspects of international commercial arbitration, where the seat of arbitration in Russia. What about arbitration agreement? I mentioned on the slide that the main features of arbitration agreement. Naila, could you please turn on the next slide? Yes, thank you. It's an agreement which must be concluded in writing, according to the Article 7 of the Law of International Commercial Arbitration. And it could be a separate arbitration agreement, a clause in the main contract, even an exchange letters, messages, an exchange of procedural documents, references to another documents, and a clause on resolving disputes in the articles of incorporation of a legal entity by arbitration. Moreover, we have international principle as competence. It means that arbitration agreement is not affected if the main contract is found invalid. What about alternative arbitration clause? They are valid in Russian Federation only if it provides an equal right to both of the parties, and disproportional arbitration agreements will be invalid. And as a general rule, civil disputes are subject to arbitration, but our rules provided a number of categories of disputes which are not arbitrable under Russian law. For example, this could be bankruptcy cases, cases regarding a refusal of registration in the state register of legal entities and individual interpretativeness. Also, it could be disputes arising from intellectual property or administrative and public related disputes, class action disputes, even some corporate disputes. For example, it's disputes related to notarized activity on certification of sales of shares contracts, or purchasing of 30% shares or more of a public company, and others. And as mostly in all countries, it's disputes arising from family relations, disputes within special proceedings, and disputes arising from compensation of damages to the environment. That was about arbitration agreement. If we are talking arbitration, if we are talking about procedure, particular about enforcement, you should know that the application for the enforcement of an award must be filed to the competent state court of the subject of the Russian Federation. And on the next slide, you see that it should be applied at where the debtor's place of stay or residence, or the location of the debtor's property if the debtor's place of stay or residence is unknown. Also, we had new amendments which were mentioned by Sergei Rosomakhov in 2017, and due to these amendments, parties are now entitled to change court jurisdiction by the arbitration agreement, and application for enforcement on the parties' agreement may be submitted to the competent court in the seat of arbitration or to a competent court which is local to the winning party. And that was like the main features in our legislation. And now I want to tell you about one study by Russian Arbitration Association on the next slide. And yes, firstly, this Russian Arbitration Association study was about recognition and enforcement of foreign arbitral awards. We in our laws have some grounds for refusal to recognize the enforce of foreign arbitral awards. It's Article 5 of the New York Convention and Article 36 of the law of ICA. And also you can find some provisions in arbitrage commercial proceeding code of Russian Federation. I think that we all know about grounds by Article 5 of the New York Convention. It's when the parties to the agreement referred to the Article 7 of the Convention under the law applicable to them under some incapacity, or the state agreement is not valid under the law to which the parties have subjected it, or failing any indication thereon under the law to the country where it was made. Also, it's the party against whom the word is invoked was not given a proper notice. The word deals with a difference not contemplated by or not filing within the terms of the submission to arbitration. The composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. The word has not yet become binding. And two additional reasons is that the subject matter of the difference is not capable by settlement by the arbitration under the law of that country, and also its public policy. And then I will show you one study. Naila, could you please show it? Yes, it's the Russian Arbitration Association study on the application of the New York Convention in Russia during 2008 and 2017. And I just copied from the Arbitration Journal some statistics about it. On the next slide, you will see the year-by-year numbers of recognition and enforcement cases. As you can see that after the crisis on 2008, the number of cases was rising. In 2008, it was 11 cases. And you can see that in 2018, it's 87 cases. Moreover, you can see that each 3 years, you can see more cases, for example, in 2011, then 2014, 2017. Then on the second graph, you can see average time between the dates of recognition and enforcement application and recognition and enforcement court ruling. As you can see, it's like 314 or it was in 2008. Now it's like less. It's mostly like everywhere, like each year close to 200 days. So it's not so much actually for enforcement. Like mostly it's half of the year or a little bit longer. Also, I think that it depends on the region, because mostly cases the climates that trying to go to Moscow State Arbitrage Court, and there are a lot of cases there each day. So the judges can be busy, and they, for example, will have time to hear the case, like each hearings maybe once per 2 months. So, but if it's it will be other regions, it will be faster. Then on the next slide, you can see 2 more graphs, the seat of arbitration. And mostly, as you can see, the seat of arbitration, it's Ukraine and Belarus. It's like close countries for Russian Federation, and then goes England. As you can see that there are a lot of businesses in Russia who will prefer to settle the disputes in England, not only in arbitration, in the English court too. Then it's also Kazakhstan, Lithuania, Latvia, Moldova, and others. And if you are talking about nationality of the claimants, you can see that also mostly it's Ukraine, Belarus, and parties from post-Soviet Union. And one more slide with two graphs. It's exactly and particular about the general statistics on the recognition and enforcement each year. And you can see that most cases they're granted. Like it's in 2000, you can see it's in 2008 and in 2017 that mostly all cases will be granted, and only few of them will be rejected. You can see the most rejected cases were in 2017. Some of them will be not accepted, and almost none of them were terminated. You can see that only in 2011 and 2012 were 1 and 4 cases which were terminated. And the most interesting number of conventions, Article 5 defenses. And you can see that mostly it's public policy, as we understand that. I think that mostly in most countries, public policy here is the most important. And the second, the lack of proper notes. It's like 38 cases. And then here you can find that some of the articles are not filed. For example, it's the subject matter of the dispute is not capable of settlement by arbitration. And you can find these full statistics because it includes a lot of different graphs about, for example, arbitrators, not only about seat, but about the applicable rules, and more statistics about each year. Moreover, Russian Arbitration Association are preparing each year such kind of statistics, and this year I'm one of the group authors about practice of 2019. I hope soon we will publish these statistics. So on the last slide, I mentioned some resources where you can find, and here the distribution on of Article 5 grants per year. Here, as I told you, that you can see that mostly it's a public policy is red, as you see in the first graph. In 2013, for example, you can see that there were a lot of cases based on it, and 2017 year. And the last slide is number of invoked and granted public policy defenses. And yes, 1 second. And here you can see that violation of the public, where the violation of the public policy was invoked and were granted. And mostly you can see that almost all cases were granted. For example, in 2008, it's like 2 were invoked, 1 granted. In 2013, 15 were invoked and only 4 were granted. And in 2014 and 15, none of the cases were granted, but in 2017, you can see that mostly all cases were granted. Yes, and as I told that in the last slide, I mentioned all sources which I used for this presentation. So thank you for your attention. I hope that for you it was quite interesting to hear from about enforcement from Russian perspective. I know that Russia and Indonesia had and now has disputes in international arbitration and commercial relationships between two countries becoming closer and closer. So I hope it will be useful information for you in the future. Thank you.
Thank you, Ms. Irina, for a very thought-provoking yet interesting presentation. What we should highlight the most is that after the financial crisis in 2008, the number of the application rapidly increasing. And in the Ukraine and Belarus is the most applied arbitration tribunal. The most grounds that was brought by the defendants is regarding the public policy as accordance to Article 5, Paragraph 2, number B, under the New York Convention. Thank you once again, Ms. Irina. Moving on to our second speaker, Mr. Ricardo Gonzalez, LLM, that is currently positioned as the Deputy Chief Legal Officer at Prospera Arbitration Center in Honduras. Mr. Ricardo graduated from University of San Pedro Sula, Honduras, and the Pennsylvania State University for his master's degree. Mr. Ricardo will kindly deliver his presentation regarding the practice and regulation of the enforcement arbitration awards in Honduras. Please welcome Mr. Ricardo.
Thank you very much, Naila, and good night and welcome everybody. I'm glad that all of you are able to assist to this type of presentations. It's very important for the population around the world to be informed and educated in regards to alternate method of dispute resolutions. Today I'm going to talk about my own country, Honduras. Probably many of you, except by today, probably have never heard about Honduras. So let me just give you a little bit of context. Honduras is a Central American country located right in the middle of continental America. It's right next to El Salvador, Guatemala, and above Nicaragua. Honduras is a developing country, really small, with a population of around 9 million people and 112,000 kilometers squared on its area. We've gone through many changes throughout history in which Honduras has slowly but surely developed into the future. After several different governments, including some military governments around the 80s and 70s, Honduras has slowly approached the alternate method dispute resolution, such as conciliation, mediation, and arbitration. Naila, if you help me go into the next slide, please. Honduras barely ratified the New York Convention on October 3rd of the year 2000. It was then that Honduras was ready to start getting involved with the international community in a global scale, trying to gather investors to start actually taking a focus in Honduras. Previously, we were a banana republic in which our main commerce was based in banana companies established by the US back in the 50s and 60s. By joining the New York Convention, this was a sure method in which Honduras as a country in its developing stages could promptly assure investors that there would be an assurance that making businesses in Honduras would be a safe investment and they would have a safe legal platform to establish itself on. It was back then in October 2000 that by joining the New York Convention, we were able to actually start accepting the enforceability of arbitration awards from foreign countries. However, it was around the same time that Honduras created its own legislation to talk about arbitration, conciliation, and mediation. Next slide, please. Exactly on the same month that we joined the New York Convention, the Honduran Congress enacted the National Decree number 161/2000. It was October 16th, so exactly the same month. At that time, we created this law specifically called the Conciliation and Arbitration Law. With this law, Honduras was able to properly assure that arbitration centers were going to be established around the country, procedures for arbitrations would be regulated, and as such, we created this platform in which we were sure that would be beneficial for the country in the future days. This law specifically is a conjunction of laws that we have. We're not like Russia, as Ms. Irina previously talked, that they have a couple of more legislations about it. This is the only one we have specialized for arbitration in our country. Because of the fact that we're a developing country and we're not really big, we often look into our neighbors and world countries that are renowned in developing proper platforms for legal jurisdictions to be built upon. And as such, we took the examples and followed the guideline of Arbitral to be able to create this law. But besides this law, we'll see the next one as well, please, Naila. We also have the Civil Procedures Code. The Civil Procedure Code was enacted in 2006. You'd think this probably was very, very early, like it was just barely a decade and a half ago. What happens is that previously in 1906, we had a civil procedure, well, not even civil procedure, a procedures code that would regulate every single procedure to be taken upon in the country. And that would just regulate everything. Criminal procedures, civil procedure, commercial procedures. So in 2006, trying to modernize our legal structure, Honduras enacted this civil procedure code in which specifically civil affairs and commercial affairs at that same time would be regulated. And in this massive code, because it's very big, it's very heavy duty, we have several rules in regards to how we're going to deal with civil and commercial affairs. Book 6 of this civil procedure indicates exactly the fact that we as a country can assure for foreign investors that foreign arbitral awards are enforceable in our country. Chapter 4 of that same book contains the action procedure for that. Let's go ahead, Naila. Next slide, please. Okay, right. So I think you went one too far, maybe? No, that's fine. All right. So this is a textual, or well, not necessarily textual, but a free translation I made myself of the Honduran Civil Procedure Code. Article 753, it establishes that for foreign titles or foreign awards to be considered as valid resolutions in our country, in our jurisdiction, they should be that, specifically resolutions. They would have to ultimately put an end to a matter in a definitive character in which we would assure that this award is not just a stepping stone in a process. This would definitely solve the conflict, and our courts of law wouldn't have to necessarily take a second look at it. All right. So by having this provision, what we're trying to ensure is that ourselves, the country, and foreign people who are looking to invest in Honduras understand that by getting an arbitration award outside the country, it would be a very easy process to actually go to Honduras and enforce it, because we would accept that as long as this was the last step in the procedure. This is a dispute already solved. We got an arbitration award. There's a prize already enacted. We're ready to go and say, okay, I have a debtor in Honduras. I need him to pay me back. I need to freeze some assets. Whatever I need to do, the courts will be able to do so. And this provision was technically brought upon because that we already subscribed to the New York Convention. So it already mentions that we will follow any international treaty that we are subscribed and ratified on. Honduras has a pyramid of importance in regards of how we follow the laws in the country. This pyramid taking into account that the Constitution is on the top, but right next to it, it's international treaties and conventions that are regulating things and businesses and human rights in the country. Below that, then we have civil procedure codes, we have different laws, statutes, and other provisions. So having it placed upon in our civil procedure code, it's a good way to actually make sure that we understand that it's not only national law, but international law that allows us as a country to enforce arbitration awards that are given outside of our jurisdiction. Next slide, please. You went one too far. Or, no, okay, yeah, that's the next, sorry. Okay, so going back to the Conciliation Arbitration Law, Article 89, it establishes about the recognition and enforceability of the arbitral award. So again, our Civil Procedure Code already establishes that we will enforce arbitral awards emitted in other countries. And now we have the second law that talks specifically about arbitration, specifying that, again, we will recognize and we will enforce the arbitration awards that are executed outside the country and are able to be executed in our country, in accordance, again, to treaties, pacts, and conventions from international law. Next slide, please. So when we talk about competence, I don't want to go and be redundant and talk about the competence principle, which we already know about arbitral courts being able to decide upon their own competence. In this case, I'm talking about the specific competence that our courts have to enforce these arbitral awards. Now, usually, if we have domestic arbitrations, any court would be able to go ahead and take a look into it. Any court would be able to enforce an arbitration made by our own domestic arbitration centers. However, when we are trying to enforce an international arbitral award, we would have to go and file the claim straight up to the Supreme Court Justice. Next slide, please. So one interesting thing that we have to take into account is that if we're bringing an international arbitral award, we most likely have this arbitration made in different languages. And most likely any single arbitration clause or agreement that has ever been drafted where Honduras is part of, it will definitely have a provision stating that the award must be emitted in whatever language the arbitration took place in, but also it has to be done in Spanish so it can actually be easier to enforce inside our country. Otherwise, if it was not made already in Spanish, this arbitration award will have to be translated into Spanish, which is Honduras' official language. And by doing that, we would have to go and seek a certified licensed translator that are specifically recognized by the court. So we would have to go into the court and ask for a referral of a specific Spanish translator that can have a translation that can actually be useful to the court. Now, as I told you previously, I translated myself those textual extracts from our laws. That's a free translation. I'm not able to do that. We would have to go and look into a professional who dedicates itself to do that. So if you're ever in the situation where you have to enforce an arbitration in Honduras, know for a fact that you'll have to need a translator for Spanish. Next slide, please. Okay, now, in general, it's really easy to establish that a court can go ahead and accept our arbitral awards. However, we do retain the figure of an opposition. This opposition means that we technically can still do something about when the other part is not happy with the result of the award. And he may not be happy about what that award says because of many reasons. But in Honduras, that party has the benefit to claim that that award should not be valid. They will oppose to actually ask the court not to enforce it. What type of reason could this be? In general, we would be looking into that the arbitration was, one of the parties of the arbitration was technically incapacitated to either be part of the arbitration or to, in general, take part in arbitrations, which means that when the party went into the arbitration, they did not have the proper representation for it and have somebody who was incapable of handling that situation properly. Now, also there's the part where the agreement might not be valid because the law that was used by the parties was not the same that they submitted in the arbitration agreement. And that would be a major issue on that part. Now, the party against whom the award is invoked has not been duly notified. And this means that in any situation, however this could happen, the arbitration is one-sided and there's only one part present and the other part was not notified about the whole proceedings and the whole arbitration situation going on. And this would be an unjust and unfair trial by the arbitral court. And that would require for our government, who believes highly in justice, not to be able to enforce it because it would be a violation of the rights that our citizens and our businesses have here will be heard before any type of enforcement. We also have the fact that if the award refers to a controversy that was not provided in the arbitration agreement as such as it's been done internationally, that can also affect. So if I'm claiming something from another company and there was a conflict that aroused by something that was not covered by the arbitration agreement, that could also be a reason to oppose and to actually get a denial by the court if asked by the party who's being prejudiced. However, there might be provisions that actually help out and say that if something happens and any dispute that arises from that relationship with the businesses, that could create possible subjectivity for arbitration. That could also be a reason of why it could be admitted. Now, if the composition of the arbitral tribunal of the arbitration procedure has not been adjusted per the agreements with the parties, that would also be seen as a reason of being opposed. And if for some reason the award is not binding the parties or has been annulled by other court outside the legislation where the award was made of. Now, that's not the only way in which the parties could get still like a get out of jail free card in an arbitration award. These are just reasons on which one of the parties can oppose the arbitration award. It can be done by any party, honestly. Even if you want the arbitration, you can still be opposed to it. But there's one specific occasion in which when Honduran courts would straight up and say, no, we cannot accept this. If you go, Naila, to the next slide, please. The court by itself, ex officio, like by its own act, can deny that recognition if the issue or the conflict that arises, it's not subjected to arbitration. That would be an error because Honduras has a very specific amount of topics in which we cannot have an arbitration for. So in general, in Honduras, you can have an arbitration over any conflict that has arisen in between regular people or businesses in any area, civil, commercial, tax, public or private. You can have an arbitration over it. However, there's some reasons or some topics in which we cannot arbitrate. For instance, we cannot oversee criminal acts. We cannot talk about family affairs such as getting severance or getting a pension in a family matter. We cannot arbitrate over a divorce or any sort of those things. We cannot have an arbitration over another matter that has already been settled and it's already been called for. And also we cannot have an arbitration over matters in which we would need our district attorneys and the Office of Investigation to be part of. That's a public procedure that needs to be taken into our own legal system, not through an arbitration, and much less an international arbitration. And in general, we cannot have any arbitration in regards to businesses that are dealing with anything illegal, considered illegal in Honduras. Other area in which we cannot arbitrate, for instance, is in labor law matters, because Honduras believe in the freedom and gratuity of accessing justice. You cannot force, because of how expensive an arbitration may be, you cannot force an employee to go into arbitration. He has to have the right for a free trial. Hence, you cannot have an arbitration dealt over labor matters. And if that's the case in any other country, that still couldn't be enforceable in Honduras. Next slide, please. Okay, let's go through the process conclusion. And for this, I'm just gonna go ahead and talk a little bit about what it would require for the procedure to start. So I already talked about translating the arbitration award. Now we would have to file, once we have the translation done, we would have to file an execution of an extrajudicial title claim. This is the way that we handle our international awards in Honduras. We treat them as extrajudicial claims. These matters are made specifically for us to just enforce over any matter. Honduras sees extrajudicial titles such as bank checks, promissory notes, stock sales. This kind of transactions would say that you already have the right, you don't need to prove anything. Just by providing the document, you're already proving that you have the right to enforce something. So we take this into account, and you would have an attorney draft from Honduras, of course, the execution of the extrajudicial title, and then it would annex the certification of the arbitral award with its translation in Spanish if it's not already in Spanish. And this claim might contain details regarding what assets the debtor has and that could be seized and that would cover the price of the arbitral award. Now, as per the admissions, the court would receive it and admit that claim in a couple of days. It should take up to 5 days for a court to receive that claim, and it would issue an executive order to determine the person or entity whom the award will be enforced upon. So for us to enforce the arbitration award, we would need to know the address or place of business of where we are supposed to go and notify the person that we're about to enforce this arbitration agreement upon. In order to determine that this, like, the claimant will have to provide this information or would have to conduct an investigation to find the place in which this would happen. The order that will be made by the judge will include the amount to be paid and a warning that if there's no prompt pay of the debt, there could be a possible freeze of the assets that would cover this claim. And of course, then we would enter into the fact that the person could say, okay, no, I don't want my assets seized. So they could provide with a lump sum that could be freezed instead. This process generally takes, once it's translated, it's filed, the order executes the award, around 3 to 5 months if there is no oppositions. There is no set time on stone because once this claim is filed into the Supreme Court Justice, it would have to be appointed into the judge that actually handles that division. And after that judge has it in his power, then it would have to do the proper filing and issue the order necessary for the claimant to collect the debt. And in the case that there is an opposition, and we already saw the reasons for oppositions, we might look into a further date up to around 8 months to 10 months. Now, Honduras has never been a country that is known to be a arbitral seat or a place of arbitration at all. However, on the last couple of years, the Prosper Arbitration Center was created inside of one of our special economic zones in Honduras, known as Prospera Sede, and this is looking to be the general arbitration seat in place for all Latin America, in which the arbitral awards are being provided in around 6 months as well, and will be able to give you the best service as possible and be enforceable in different countries, as it's also subjected to the New York Convention. And that's about it. Naila, can you go to the next one? I hope that you all found that small pass through history in Honduras and the process of how arbitral awards are managed in my country. It was a pleasure to talk to you all, and I'll be here for some questions later.
Thank you, Mr. Ricardo, for the amazing presentation. I personally, and I believe every participant here, is highly amused to the, particularly to the thoughts that in Honduras, there must be a definitive character from the final arbitration words as accordance to the Honduras Civil Procedure Code. It was very interesting to be further discussed by the participants here. Now, we would like to welcome all the participants to ask regarding the enforcement of the arbitration awards from Russia to Ms. Irina or to Mr. Ricardo from Honduras. We will open 2 inquiries for 2 participants. Please write your inquiry in the comment section and mention your name, institution, and to whom the question will be addressed. And please arrange your best inquiry since there will be 2 best participants that will be chosen by the organizing committee. Or maybe Mr. Sergei Rosomachov, would you like to inquire any questions? And maybe any other speaker, Ms. Irina, Mrs. Prita, or Mr. Jeffrey, would you like to inquire? All right, if there are no inquiry, would like to proceed to our next presenter, Mrs. Dr. Prita Amalia SHMH. She is currently an international commercial arbitration lecturer at Faculty of Law, University of Pajajaran. Mrs. Prita graduated from University of Pajajaran as the best graduate, and Mrs. Prita is highly passionate as the expert in the arbitration law, investor-state dispute settlement law, and the international private law, especially from Indonesian perspectives. For Mrs. Prita, the time is yours.
Okay, thank you, Naila, for the warm introductions. And also, for these occasions, please allow me to express our gratitude first to our partner, Bursa Hukum, LBM lawyers, especially to Bapak Tri Januar Putra. He is our alumni and also very support to have discussion, especially for the international arbitrations. And for Russian Embassy in Indonesia, Mr. Sergei Rosomakov, and thank you very much for the invitation to us, Faculty of Law, Universitas Pajajaran, to be one of the organizer. And hopefully this is not the end, or this is not the one of, they would be one of our collaborations, and hopefully in the future we expect another collaboration with you. And also very pleased to me to be one panel with the Miss Irina from Russia and Mr. Ricardo Gonzalez from Honduras. It is a pleasure to meet you even in the pandemic situation by screen. However, we really respect and as well as appreciates for joining with this webinar. And thank you as well to our Dean of Faculty of Law, Mr. Idris SHMH, who expressed the welcoming remarks. And unfortunately, he should leave from our webinars due to another meeting. So, Naila, I will try to share screen for the presentations. My presentations is okay. Hopefully all the participants could see the presentations, Naila.
Yes, we can see it clearly, Ms. Rita.
Okay, thank you. Okay, talk about the enforcement of International Arbitral Award, especially for the Indonesia perspective, is still really interesting. However, I've been research on this topic since 2005, especially for the limitations and the interpretations of public policy. So from the Ms. Irina and Mr. Ricardo presentation, public policy, I believe as a keyword for the enforcement of foreign arbitral award. So looking forward to have another discussions in to what extent the country or the state court interpret and limit the public policy interpretation. I think we also have these questions from Pak Idris remarks early. So I believe the participant could share their knowledge or their insight on how the public policy could interpret in relation with the enforcement of foreign arbitral award. And it is also really interesting to have a comparison study with Russia and as well as with the Honduras. Previously, we will have a Spain perspective, but maybe later in the next event. And in my presentations, I would like to use this prestigious opportunity to introduce you to our department, and it is really close relations with the arbitration, especially at the Faculty of Law, Universitas Padjadjaran. We show the focus and as well as the concern of the Faculty of Law, Universitas Padjadjaran in the development of the international commercial arbitrations, with established the new department, Transnational Business Law Department. This is one of the department at the Faculty of Law, Universitas Padjadjaran. Currently, Universitas Padjadjaran Faculty of Law has 9 departments, and Transnational Business Law Department is one of the department which established in 2019 as a response to the development of law in the globalization era, international economic law and international trade law issue, as well as the international commercial arbitrations and the investment arbitrations. So this is the numbers of the subject that that all the students from the Transnational Business Law Department will learning on. And this year, the International Commercial Arbitrations and IDR would be the compulsory subjects in our faculty. And all of the students, not only from the Transnational Business Law Department, will get the knowledge about the arbitrations and ADR law. So this is our concern in the arbitration law development, especially in Indonesia. And of course, to understand and has a comparative study with the other state is really important to us to understand completely about the arbitration law. So in these occasions, we would like to invite the collaborations in the future with the Miss Irina or Mr. Ricardo, as well as with the Bursa Hukum or other participants to join with us to develop this subject together with the Transnational Business Law Department. And next, related with the arbitrations, before we talk about the enforcement of foreign arbitral award, I believe to understand why arbitration is still important, why the knowledge of arbitration, especially international commercial arbitration, is important for the student, for the lawyer, or for us as a community, is because of numbers of the factor. I'm trying to inventorize the numbers of the factor which give the impact to the development of the arbitration. First of all is the globalizations. We believe the transactions borderless, international business transactions is quite developed. And since the international business transactions is developed, the cooperations between numbers of the partner overseas or in borderless make numbers of the contract as well as the international agreement is growing rapidly. As we know that now the free trade area agreement or the comprehensive economic partnership agreements is developed, and with the numbers of the chapter related to the trade in goods and services, and also about the investment chapter. And if we talk about the transactions and how the business in one of state is conducted, we also need to understand about the ease of doing business. Ease of doing business is some of rank that the state have their own rank, which get by the indicator on how the regulation in their state is familiar or conducive to conduct the business and business transaction internationally. And this is also one of the consideration that we should improve our regulation, especially in arbitration and international arbitration. From the presentations by Irina and Ricardo, I got the word investment. So business and investment are the two kind of activity which consider for the state to get the highest rank or the good rank in ease of doing business. And the next factor is the Industry 4.0. We believe that in this pandemic situation, the arbitration is also develop and adjust with this condition, especially with the condition of the Industry 4.0. Numbers of the institutional arbitration is trying to adjust the proceedings of the arbitrations by made some rules about the online hearing, use the video conference in the proceeding in the arbitrations proceeding. So this is only the small or numbers of the factor, and maybe we could inventarize or add numbers of a factor on how the arbitration is still important on and develop and developing. And this is also the reason or the argument why the arbitrations is important. As we know that arbitration has numbers of the advantages, which we could not find in other method of dispute resolutions or method of dispute settlement. And these advantages is still important in the developing of the arbitrations. However, numbers of the organization also complete their organizations by establish the method of dispute institution in their organization to strong the functions of the organization. As we know, in Indonesia, we have lembaga penjamin simpanan with the OJK with LAPSPI, Lembaga Alternatif Penyelesaian Sengketa, which also provide arbitration as one of the method of dispute resolutions. And another argument is the connections between the quality of arbitrators with the quality of decisions making. As we know, this is one of the advantage of the arbitration, which not only lawyers or a person with the law background who could be the arbitrators, but engineering, doctors, or other profession could be act as an arbitrators with their competency. So this is also give the implications to how the quality of decisions making, or we could understand as the arbitration award. And next is the confidentiality, which is this character that arbitrations make very important for all the parties, since when we talk about arbitration, we talk also about the business, the quality of business, and the confidentiality is trying to build the good reputations to the business parties, which is sometimes dispute is one of the barriers in the business development. So with the confidentiality characteristic by the arbitrations, it would be helpful for the business process. And last is because this arbitration is familiar or popular in every region. So the standardizations of international arbitration practice now is happen in every region. They have a focus on the standardization internationally. That's why now numbers of the organizations provide the certifications for the arbitrators, and also numbers of the conventions regulate about the international arbitration. By this, it would be make more certainty and confidence in the developing of the arbitrations. We still talk about the advantage of the arbitrations. I'm trying to be more focused on the advantage of the arbitrations for the numbers of the keywords for the advantage of arbitration, which we could not found in another method of dispute resolutions. We have already discussed about the confidentiality and also about the arbitrator. The arbitrator, as we know that not only the lawyers could be an arbitrator, however, the arbitrator should have the characteristic independent and impartiality. This is why the arbitrations is also interesting for all the parties who have a dispute. Since the arbitration should conduct independent, and how if the arbitrator could not implement or has not a characteristic independent and impartiality, we could say that it known as a biased arbitrator. And numbers of the regulation stated that for this occasion, the arbitrator could be withdrawn and replaced with the new arbitrator, which the qualification and fulfill the qualification and the requirement based on the regulations. And the most important things as a source of law in the arbitrations proceeding is the party autonomy, or the law of the parties. On how the arbitrations proceeding conduct, it should based on the law of the parties, which law that the parties chosen as their law, as well as which the procedural law that the parties chosen in the arbitrations proceeding. And this is the chart that I note from the source is from the Queen Mary University. From the chart is released on 2018. However, hopefully it's still relevant for this year. On how the arbitration is still popular or chosen by the parties in the cross-border dispute. From this chart, we could show that 48% and 49% arbitration is still popular with or without the alternative dispute resolution. From this chart, we could also argue that arbitration sometimes is different with another alternative dispute resolution. Consider the award of the arbitration is final and binding. And this is the rank of the data about the ease of doing business 2020, which you all of you could access from this link, from this address. And as shown by this data, Indonesia was placed at 73, and we could compare it with another ASEAN state, Singapore, placed at second place, and Malaysia 12, Thailand 21, and Vietnam 70. However, this is the new achievement. I mean, the new rank for Indonesia. Previously, Indonesia is 91 on the rank of ease of doing business. And Professor Zain Umar Purba said in one of the occasions in the seminar that the arbitration has contribution a lot to improve the rank of ease of doing business. So hopefully by these discussions, we could deliver numbers of the point on how we could improve our Indonesia arbitration law by have a comparison study with another state, Russia, Honduras, or hopefully Spain or the other state. I believe that numbers of the participant is coming from Indonesia, but since we have Miss Irina and Mr. Sergey and Mr. Ricardo, or if another participants coming from the other state, I think it is also important to introduce you to our Indonesia arbitration law. As we know that since 1999, Indonesia regulates the arbitrations by law number 30, 1999. And the title is Arbitration and Alternative Dispute Resolutions. However, if from the title we understand that this law will discuss about arbitration and alternative dispute resolutions in those method, but I could say that this law actually is regulate about arbitration a lot and only regulate about the alternative dispute resolution only in one article. It is on Article 6. And this is numbers of the institutional arbitrations in Indonesia. This is we have only 3 on the screen. However, there's numbers of the institutional arbitrations that I could not provide this in my presentation. As we know and previously mentioned by this speaker that Indonesia has a BANI, Indonesian National Arbitration Board, and Indonesian Capital Market Arbitration Board or BAPMI, Badan Arbitrase Pasar Modal Indonesia. So it differences on the subject matters or what kind of the subject matter that could submit to these institutional arbitrations. And we have as well National Sharia Arbitration Board, or before previously this is BAMUI or Badan Arbitrase Majelis Ulama Indonesia. From the names of the institutional arbitration, we could understand that this institutional arbitration is for the Sharia subject matter related to the Sharia. And Indonesia has an Institute Arbitrator Indonesia. This is a professional arbitrator organizations. We believe that numbers of the professional arbitrators organization is already also we familiar with numbers of the professional arbitrators organization internationally. So this is on how when we talk about the enforcement and recognitions and enforcement of foreign arbitral awards, so we have to understand to what extent that our Indonesian law regulate about the international arbitration or about the international arbitration award. I could say that in Indonesian arbitration law, we could not find the definitions or the limitations or the interpretations about the international commercial arbitration. What we only provide by this law is the definition on arbitrations. Arbitrations based on the Article 1.1 means a method of settling civil dispute outside the general court based on the arbitrations agreement made in writing by the parties to the dispute. So similar with the Russia, which provided by Ms. Irina, that arbitration agreement is also the source of law to proceed the arbitrations proceeding under Indonesian law and stated clearly on the Article 1.1. And the questions is, does this arbitration could also apply in Indonesia for the international commercial arbitration or not? Since we cannot find the terminology of international and commercial, so we could say that Indonesia arbitration law is until now is only understand or only regulate about the domestic arbitration. However, numbers of the articles on law number 30, 1999 also stated or we could use or apply for the international arbitrations. This is another definitions that related to the enforcement and on foreign arbitral award is definitions on international arbitration award. In this law, regulated on the Article 1.9, International Arbitration Award is award handed down by an arbitration institutions or individual arbitrator outside the jurisdictions of the Republic Indonesia, or an award by an arbitration institutions or individual arbitrator which under the provisions of Indonesian law is deemed to be international arbitration award. This is these regulations or these definitions about the International Arbitration Award is interesting, since one of the dispute, Pertamina versus PT Lyric Petroleum, is questions about the definitions of the International Arbitration Award. This case is proceeded by the International Chambers of Commerce. However, the proceeding is conducted in Jakarta. So the arbitration award is produced in Jakarta, and it would be some interesting topic to discuss, and this is also the case. Since the award is resulted or produced in Indonesia or in Jakarta, thus the award could be deemed as international arbitration award or not. If we use these definitions, Article 1.9, by regulations or the statement handed down by an arbitration institution or individual arbitrator outside the jurisdiction of Republic Indonesia, it will be interesting since the court stated that this is not could be deemed as international arbitration since produced in Indonesia or Jakarta. So I think it would be interesting to discuss with you, or perhaps the participant have another insights, or we could share in this webinar as well. And this is the absolute competence in the doctrines of the competence that previously mentioned by all the speakers. In our Indonesian law, it is stipulated on Article 3 and Article 11 in general that when the parties has an agreement with the arbitrations agreement, so the district court has no jurisdictions. And I think this is what we could understand as an absolute competence. And this is also regulated or stipulated in under UNCITRAL Model Law on International Commercial Arbitrations, 1985. And how our Indonesian law regulate about what kind of the subject matter that capable to settle by the arbitrations. It is stipulated on Article 5 that in this article stated that the only dispute which may be settled by the arbitrations are dispute in the commercial sector concerning rights which according to the law and regulations have the force of law and are fully controlled by the parties in the dispute. However, we could not find again the explanations in what extent that the commercial sector means by this law. So comparing with the UNCITRAL Model Law on International Commercial Arbitration 1985, we could find the note from the Article 1.1 of Model Law that the terms commercial should be given a wide interpretation so as to cover matters arising from all relationship of commercial nature. So the point is when we decide that the subject matters is commercial or something that capable to settle by the arbitration, that the subject matter should have the nature of commercial. This is also that we could not found in our Indonesian law. Why the subject matters of commercial is important? This is also related to the next discussions about the enforcement and on foreign arbitral award, since the New York Conventions also required that the dispute that could enforce or recognize in terms of the foreign arbitral award is the subject matter should be capable to settle by the arbitrations. This is the definitions or the limitations of the international arbitrations provided by the UNCITRAL model law, since we could not found in our Indonesia arbitration law. Numbers of the factor that should consider on how the arbitrations is international. International is the arbitration has the international characteristic. The international characteristic could be considered by the place of business, place of arbitrations, place of the contract performance, place of the subject matters of dispute, or the subject matter of the arbitrations agreements relates to more than one country. So this is also important to identify first before we deal with the issue on the recognition and enforcement of foreign arbitral award. Next, this is the source of law when we talk about the recognition and enforcement of foreign arbitral award in Indonesia. Based on the international law, I think we agree that the Convention on the Recognition and Enforcement of Foreign Arbitral Award is the main source of law when we talk about this. And UNCITRAL model law on international commercial arbitration, since this is the model on how the state could make the arbitration law, also regulated on the Article 35 and 36. What about in our national law? Of course, on law number 30, 1999, especially on the Article 65 and until 69, regulated about the recognition and enforcement of foreign arbitral award. However, on how Indonesia ratified the convention, we ratify by the presidential decree number 34, 1981. And after the Indonesia ratified the conventions or New York conventions, numbers of argument rises. Thus, the convention could be implemented directly just based on the instrument of ratifications, or we need another implementing legislation. Then next, after the presidential decree number 34, 1981, we have the Supreme Court regulation number 1, 1990, talk about or regulated about on how the recognition and enforcement of foreign arbitral award could be processed, or in Indonesia is tata cara pengakuan dan pelaksanaan putusan arbitrase asing. And after Indonesia has law number 30, 1999, this Supreme Court regulation is still exists. So we could say that when we talk about the recognition and enforcement of foreign arbitral award, we still should consider the Supreme Court regulation number 1, 1990. I can show you the one of the example that not that a Supreme Court regulation provide the regulation and not law number 30, 1999. We could not find it in the law number 30, 1999. In Supreme Court regulation number 1, 1990, we could found the limitations on how we could interpret the public policy in Indonesia. So generally, public policy is norms that understand or not understand. The norms or regulation that recognized in Indonesia. Or in Indonesia, we could found it or use it under the hierarchy of law, under law number 15 now. Law number 15, 2019 as the new law. before we regulated on law number 12, 2011. And last is the national law. Under the national law, we should also consider the Supreme Court Circular Letter number 4, 2016. It is about on how Supreme Court emphasized that the arbitration award has a final and binding, is a final and binding. So there's no other steps, or this is the end of the arbitration proceeding when there's a arbitral award. This is the numbers of the principle that we should consider when we talk about the implementations of the New York Conventions. We believe and we understand that the writing agreement is the basis of the implementations of the New York Agreement between the parties, and also the reciprocity principles stated as well on the New York Convention. It means that we should consider when we would like to submit the arbitration cases to the institutional arbitration in overseas, we should also make sure or make some research. Does the state which the state that will implement the arbitration award is contracting state of the New York Convention or not? And this is not the step that we should taken in the last of proceeding, but we should consider it in the first place when we would like to submit the arbitration case to the arbitration proceeding. And last, we should also make sure that the subject matter that is capable of settlement by the arbitration, especially it is about the commercial dispute. This is the problem in Indonesia, if I could say like that, about when we talk about the recognition and enforcement of foreign arbitral award. We don't have any limitation and interpretations of the public policy principles, as we know that numbers of cases is related with the public policy principles and national interest, as we could shown from the Pertamina versus Karahabodas. This case is happened on 1997 when we have numbers of the state has a crisis, and there's some government regulations to postpone a big cases that will give impact to the economics of Indonesia. And definitions of the International Arbitration Award, like I mentioned before, it is also interesting since under Indonesian law, limited to the jurisdiction that made outside of the Indonesia. What about if there is the international arbitrations proceeding with the proceeding is took in Indonesia, does it would be also could deem as international arbitration or not? However, the UNCITRAL model law give the international characteristic of the arbitrations is clearly. So thus the international characteristic by the model law on international commercial arbitration could be used as our considerations or not. Lastly, this is a phenomena, if I could say like that, in Indonesia, when the terminology of annulment or the process of annulment sometimes is some of the people trying to trying to understand is similar with the recognition, which is it is different since the annulment and the recognitions have a different legal consequences, and the knowledge to and the I think the informations are and the knowledge that does the annulment and recognitions of foreign arbitration award is different should be understand clearly. So if I may give some recommendations related to the arbitration law, Indonesia arbitration law, especially about the recognitions and enforcement of foreign arbitral award. We understand, or sometimes we also hear that Indonesia currently is trying to amendment of law number 30, 1999. So I think the arbitration law reform should be conducted comprehensively. Especially, we should have the Indonesia arbitration law on focus with the international commercial arbitration. And of course, the limitations and the interpretations of a public policy in Indonesia is really important to give the legal certainty to the parties, especially to the parties who have a business or has investment in Indonesia, and hopefully it will be also improve our rank in ease of doing business. So I think that's all that I could share with you in these occasions. Hopefully it would be what we call it. It would be invite numbers of the invite you to discuss whether related to the enforcement and foreign arbitral award. I really appreciate if we could share knowledge or discussion with you. Thank you very much. My apologize for if there's something mistake. And we cordially invite you to have a collaborations and we could further communications by send me an email. This is the email from our department and also my personal email. Thank you, Naila, and also all the organizer. Thank you.
Thank you very much, Mrs. Prita, for an engaging presentation regarding the theory and the regulation of the enforcement arbitration awards in Indonesia. To conclude that there are 4 factors as to choose arbitration settlements as to settle a dispute, the needs of the implementing regulation about recognition and enforcement arbitration awards, and also the reciprocity principle. Those issues are indeed very interesting to be discussed about. Thank you, Mrs. Prita. From the comment section, we are pleased to announce that there is some questions for Irina. The question is from Safa from Indonesia. And the question is, what has been the approach of the National Court in Russia to the enforcement of arbitration, especially in agreement disputes? Maybe for Ms. Irina.
Yes, I can answer. Unfortunately, I cannot turn on the camera because I'm already in the court. I have hearings today. Concerning to this question, as I told that the main point to enforce the arbitral decision, it should be arbitration agreement, firstly agreed, and then after you already have decision, it's basis to not enforce decision. It's Article 5th of the New York Convention and provisions in arbitrage commercial state court and also arbitrage commercial proceeding code and the law of international commercial arbitration. So it's mostly procedural question than like material one, because as we all know that when the court enforcing foreign arbitral decision, they could not look through the material part of the case. I hope that I understood right your question and I answered to you.
Yes, thank you so much, Ms. Irina. The next one, we have an inquiry from Mr. Gary Gumelar to Ms. Prita Amalia. The further explanation about commercial dispute definition is absent in the law number 30 of 1919. Indeed, thus from your presentation, in assessing whether a dispute contains commercial nature, the definition of commercial under Arbitral is suggested to be operative. And the question is, what is the status of the Arbitral model law itself under Indonesian legal system? Can an arbiter or a judge in Indonesian court use it as its source of law? Thank you.
Okay, thank you, Naila, and thank you, Pak Gary, for the questions. This is also some interesting when we talk about the commercial dispute. To understand the commercial dispute is, I agree with you, and Arbitral model law could be used as one of the source of law to consider to what extent that we could say that the dispute is a commercial dispute or not, because this is really important to conduct the arbitrations proceeding. I believe that UNCITRAL model law has been adopted as the international standard arbitration. The status from the title is a model law. So it's look like a model on how the state could arrange or make their own arbitration law. However, Indonesia, we could say that Indonesia still not completely adopted the UNCITRAL model law. So for the next questions, does Indonesia could use this as a source of law? I could say yes, as a soft law, since this is also some of the international standardizations of the arbitrations, and numbers of these states is already use it or adopted this model law, and how they make or arrange their arbitration law. And this is also the recommendation arises by the delivered by the the representative of UNCITRAL when we have the seminar on the arbitration law reform. When we talk about the harmonization, for example, in the ASEAN countries, I think the quite challenging is to Indonesia, since Indonesia still not yet adopted UNCITRAL model law. So I think we could say this is the strong recommendations for Indonesia to take a look further to the norms regulated on UNCITRAL model law on international commercial arbitration. Hopefully it will answer your concern, Pak Gary. Thank you, Naila.
Thank you, Ms. Prita. Earlier, Mr. Prita has already explained flawlessly regarding the theory of the enforcement arbitration law in Indonesia. And this leads us to the last speakers of today's event, Mr. Jeffrey Santoso, SHLLM, CM, MPM, MCIRB, as the founding partner of the LBM Lawyers. He has many experiences regarding the arbitration law in Indonesia, and Mr. Jeffrey here will briefly summarize the practice and the reality of the enforcement arbitration awards in Indonesia. Mr. Jeffrey, you may start the presentation straight away.
All right. Thank you, Naila, for the introductions. First of all, on behalf of LBM Lawyers, I would like to say thank you to Bursa Hukum, and especially also to the Fakultas Hukum Universitas Pajajaran, because actually I'm also one of the alumni of Pajajaran University, and also to PAC for the collaboration. I would like also to say thank you to Mr. Idris, my former lecturer in University of Pajajaran, and Mr. Sergei Rosomakov for the opening remarks, and of course for the speakers, Irina, Ricardo, and Miss Prita, and also to the participants of this webinar today. Okay. Okay, hopefully I can share some thoughts about the enforcement of the International Arbitral Awards in Indonesia. Hopefully I can share some valuable informations, even though that actually Ms. Prita already shared some or a lot of valuable informations. I don't know what to present else, because maybe a lot of advantages has been presented, and I think I'm going to present some downside or maybe the disadvantages of these arbitrations, especially in Indonesia, because sometimes people said that arbitration is very important. Yes, it is, but actually the most important thing is the enforcement of the arbitrations. What if we can win the arbitrations, but we cannot enforce it? I think that's useless. Some practitioners say that, but yeah, I think we can say that That's some of the issue that we need to overcome. Okay, Nela, please share the presentations. All right, so this is the presentation, yeah?
Yes.
Okay, the background, I think, has been already presented also by Ms. Prita, that the background is the New York Convention, 1958. This has been ratified by Indonesia in 1991. And finally, in 1999, Indonesia enacted its own law, the Arbitration and Dispute Resolution. And also, in terms of the enforcement of the foreign arbitral awards in Indonesia, of course, we need the enforcement of the Central Jakarta District Court. So for instance, this is the gate actually. If you want to get into a building, we need to pass the gate. So in relations with the enforcement of the foreign arbitral awards, Central Jakarta District Court is the gate of our country. So every decision or every award, the foreign arbitral award, must be go through the Central Jakarta District Court to be enforced. Okay, next, Naila. Okay, requirement to enforce. There are 5 requirements to enforce the foreign arbitral awards in Indonesia. One of the first one is the arbitration must be conducted in one of the member countries of the New York Convention, because Indonesia is also one of the members of the New York Convention. So once the arbitration proceeding conducted in one of the members countries, of course, the enforcement of the arbitral award can be conducted, can be done in Indonesia. And also already presented also before that the decision concerns must be a commercial matters. So beyond the commercial matters, all the arbitration award cannot be enforced in Indonesia. And I think this is also valid globally in everywhere, that the arbitrations is only related to the commercial matters. And also it does not contravene Indonesia's public policy or public order. Why this is a highlight? There's a highlight, public policy or public order, because we need to discuss in detail in the next slide about this public policy, because this is the source of the problem. This is the source of the issue of the arbitrations in relation with the enforcement in Indonesia. The next requirement is the stipulation of enforcement or the executor order. In order to enforce the arbitration award in Indonesia, of course, we need a stipulation of enforcement or the executor order through the Central Jakarta District Court. Once we already registered and then the stipulation of enforcement has been issued, we can enforce the arbitral award. And the next requirement is, if one of the parts of the case is Republic of Indonesia, for instance, the exit awards, then the stipulation of enforcement or the executor order not at Central Jakarta District Court authority. This is the Supreme Court authority in Indonesia to enforce this award. Okay, I think this has already been discussed previously in presentation of Ms. Prita also. Okay, next. Okay. Okay, this is the procedure or the steps to enforce the foreign arbitral award in Indonesia. There are 3. The first is registration, the second one is enforcement, and the last one is actual enforcement. Sometimes actual enforcement is not needed if the losing parties will voluntarily comply with the arbitral award. Okay, the registration, for instance, is started with the power of attorney from the arbiter. This is very simple, but actually this is very important because sometimes, or maybe always, once the hearing is processed, the arbitration process is finished, is completed, sometimes the arbiters dismissed. But please do not forget that in order to register the arbitral award in Jakarta, in Indonesia, we need a power of attorney from the arbiters. Sometimes in practice, for instance, in Singapore, in SIAC, Singapore International Arbitration Center, this is already common. Once the arbitration process is finished, the arbiter will give power of attorney to the lawyers in Indonesia in order to submit or to register the arbitral award in Indonesia. During the registration, there are some documents that needs to be submitted. For instance, the original text or an authentic copy of the International Arbitration Award in accordance with the provisions on authentications of foreign documents, and an official Indonesian translation of the text, and also the original text or an authentic copy of the agreement, statement from the diplomatic representative of the Republic of Indonesia in the country where the International Arbitration Award was rendered, stating that the claimant's country is bound to the Republic of Indonesia by bilateral or multilateral treaty on the recognition and execution of international arbitration awards. This is in accordance with Article 64 of the Indonesian arbitration law. Once the registrations and documents are completed, the Central Jakarta District Court will issue a deed of registration. It means that the registration process has been conducted, has been completed. Next, with this deed of registrations, the party can submit for the application for the exequatur to the chairman of Central Jakarta District Court. The chairman will issue the stipulation of exequatur or non-exequatur to the party that applied this application. So until this process in the enforcement, once the losing party is voluntarily comply or fulfill the arbitral award, then there is no need for the actual enforcement. It will be dismissed, or if there's an agreement with the contracting parties that maybe the arbitral award is too high, the value is too high, and the losing party cannot afford it, maybe there will be an amicable settlement aside from this arbitral award. This can be done. But if the losing party is not trying to fulfill the enforcement of the stipulation of the exequatur from the Central Jakarta District Court, then there's a right to the winning party to apply for the actual enforcement, or we call it writ of execution. This is only once the losing party does not voluntarily comply with the award. Actual enforcement will be made with or without the auction procedure to the assets. So if the losing party cannot afford it or will not comply with the award, with the arbitral award, as soon as the assets, as soon as the stipulation to the stipulation of exequatur is issued, then the asset can be auctioned in the competent jurisdiction. For instance, if the assets in Jakarta, in Central Jakarta, of course, that's the jurisdiction of the Central Jakarta District Court. If the assets is outside Central Jakarta, for instance, in Kalimantan or elsewhere in Indonesia, then Central Jakarta District Court will delegate the right to the competent district court in Indonesia to execute the assets of the losing party. So this is the procedure to enforce this arbitral award in Indonesia. Usually, most of them is only until the registrations. Once the registration is finished, the deed of registration already been secured. Usually, it will be done because mostly both of parties will have amicable settlement to comply with the arbitral award. Okay, next, Nela. Okay, same as the other countries, as long as they are member of New York conventions or other international conventions, where Indonesia is one of the members. The competence principle, for instance, the doctrine of separability or autonomy of the arbitration clause are also prevail in Indonesia. This is the authority of the arbitration clause, the authority of the arbitration forum to decide or to settle the dispute among the contracting parties. And evidence that Indonesia also ratified, or in Indonesia this is also prevail, is in Article 10 of the Indonesian arbitration law, stated that an arbitration agreement will not become void because of the main contract expires or is nullified. So of course, once again, the competence principle, the autonomy of the arbitration clause is also prevail in Indonesia. But we have to take into account that this principle or this doctrine is related to the arbitration agreement or the arbitration clause in the main contract. This is not related with the substance of the contract. It's not related with the basic norms of the contract law. Okay, next, Naila. Okay, why we are going to discuss in detail about the public policy order related to the enforcement? Because some cases, I think there are a lot of cases in Indonesia, for instance, especially, that the reason to intervene the process of enforcement in Indonesia is usually on basis of public policy or order. There's an infringement to the public policy on order. And there is no clear definition actually or interpretations even under the New York Convention or other convention and other laws. For instance, in Indonesia especially, there's no clear definitions what is the limitation of the public policy. So everyone can file to the district court that the agreement or the award, the arbitration award, has infringed the public policy or public order. This is the basis of the losing party usually to intervene the enforcement process of the arbitral award in Indonesia. So we must be very careful with this, because if I may recall, if I'm not mistaken, back in 2007, there's a case in Indonesia between PT Cipta Krida, if I'm not mistaken, versus Bulk Terminal SV. This coal mining industry issue. One of the parties, which is PT Cipta Krida, filed to the district court Jakarta to cancel the arbitral award in Indonesia. And what basis? The basis is very simple. Actually, this is administrative issue. There are two issues that they are that they were trying to submit or to request to the chairman of the district court. One is that the addresses of the arbiters were not put into the decision or into the arbitral award. This is very simple actually. The addresses of the arbiters were not put into the arbitral award. Arbitration, there's a typo on the arbitration fee. For instance, maybe it $100,000 US dollar, for instance, or 100 million rupiah, for instance, and then it is stated in the arbitral award that it's 99, for instance. This is also very administrative. It should not it is not the substance of the contract, it's not the substance of the proceeding, it is administrative. But unfortunately, the court has granted that yes, the one who requests can be accepted, and then the arbitral award was cancelled. Maybe in international practice, it's not cancellation. Actually, we call it revocation. We usually recognized as under Article 70. It's called cancellation. So many cases in Indonesia that need to be aware that not even the substance, not even the best, the district court can cancel or can say that there is no executor order to the arbitral award. One of the experts in Indonesia, if you may say, Yahya Harahap, already said that generally interpreted, the public policy or order is generally interpreted as conformity to the prevailing laws and regulations. It means that once the arbitral award is in conformity to the prevailing laws and regulations, then the public order has been infringed. So we need to discuss this in detail for the next slide. Please, Naila. Okay, irregular contract. I think this is not common to discuss about the irregular contract, but these irregular company contracts relate to the public policy or order. As per the previous slide, as mentioned, that the public or order is interpreted as a conformity to the prevailing laws and regulations. And this inconformity to the prevailing laws and regulations might affect the enforcement of the foreign arbitral award, especially in Indonesia. Sometimes we found the issues of the irregular company contracts in the international commercial contracts. And it is commonly caused by the distinction of legal systems among the contracting parties and the unawareness as well as unknowingness of the issues of the contract and or the company law of the counterpart jurisdiction. So we must be very careful with this. Well, the issues of the irregular company contract usually relate to the basic norms of the contract law. Hence, it does not touch the substance of the contract at all. We all agree that examination of the substance of the contract is solely the authority of the arbiters. Yes, we agree about that. But once again, the issues of the irregular contract is not the issues of the substance of the contract, but the issues of the basic norms of the contract law. Actually, there are some other types of irregular company contract. I think I forgot to mention here once. One of them is actually pre-incorporation contract. And also there's another type of the irregular contract, which is the registered foreign company, like in UK, but it's not applied in Indonesia because foreign investors are required to establish foreign investment company in Indonesia to commence their business in Indonesia. So there are actually three main irregular company contracts that may affect the enforcement of the foreign arbitral awards in Indonesia. If I may discuss the first regular company contract species is a pre-incorporation contract. It is not stated in this slide. Sometimes for many commercial and investment reasons, a company contract is signed prior to the incorporation of a company. Not yet. Yeah. Usually it is signed by the promoter. The issue is when the company has been legally established, how does the company take over all the rights and obligations of the contract? And what is the consequence if the takeover has not been properly conducted? In Indonesia, the ratifications of the pre-incorporation contract shall be conducted through a general meeting of shareholders. Some other countries, for instance, United Kingdom, they do not recognize ratification of the contract through a general meeting of shareholders. In UK, company must take over the rights and obligations of the pre-incorporation contract through a novation agreement. So it's very different. It means that the takeover must be agreed also by the promoter who signed the pre-incorporation contract. and the newly established company for sure. So if one of the parties, which is promoters and also this newly established company, do not want to sign the novation agreement, then there are no taking over. And what is the consequences? We will discuss next. What is the consequences of these irregular company contracts? This is related to the void and voidable contracts. If we are talking about the void and voidable contracts, of course, we are talking about the basic norms of the contract law, not the substance of the contract. And the second is the ultra virus contract, or we call it corporate capacity or the rules of capacity. This is also still prevail in Indonesia. This is the old school, or this is the old common law legal system. The ultra virus doctrine expresses that any contract entered into by a company outside its objects set out in the objects clause of the company's constitution or article of associations is not enforceable in law, or void. We can say it's void, null and void. For instance, an Indonesian company, a mining company, as per its object clause, the company's constitution signs a contract with other party to conduct construction project, for instance, the construction project. While construction is not stated in its object clause, so construction is not part of the business line of this company. As per this ultra virus doctrine, this contract shall be null and void. Unfortunately, this doctrine of ultra virus still prevail in Indonesia, while other developed countries, for instance, US, maybe UK, or even Netherlands. Netherlands is the origin of Indonesian civil code, have abolished this and restricted this ultra virus doctrine. So they already abolished long time ago, while Indonesia still prevail. So for them, one company for any businesses. So the legal consequences of the ultra virus contract under Indonesian law is nullity, so that there are also further legal consequences on the contract. For instance, company is entitled to refuse the perform of the ultra virus contract. The company cannot be sued. The general meeting of shareholders as the organ of the company is not allowed to ratify and approve the contract entered into by the board of directors on behalf of the company. And also the third party is not protected even though the contract is entered into by a good faith. Is this common happen in Indonesia? Yes, it is common. And it's common for the international commercial contracts, because unknowingness, because unawareness, what is the company law said in one of the counterparties jurisdiction. So that's why maybe in this global era now, so many online contract have been made, and this is the potential issue that can be happen in the future. The third is the contract involving access of directors of officers' authority or other internal procedural flows. This might potentially appear on the effect of a contract executed without authority and power given to the directors or the subordinate agents under the company's constitution, or in Indonesia we usually call it articles of association. In Indonesia, the contract entered into by the board of directors without authority or other compliance to the internal procedures of the company shall be valid only if it provides actual benefit to the company or it is ratified by the company. Otherwise, the contract is voidable. Indonesian legal system in this particular matter is different compared to other legal system. For instance, English law, which recognize indoor management rule. Indoor management rule is when the third party dealing with the company in a good faith they are entitled to assume that any internal procedures contained in the company's constitution have been properly complied with, even though there are still some exceptions to this rule. But at least there's a protection to the third party who is dealing in good faith with the other third party, with the company in Indonesia. So is this related to the substance of the contract? Of course not. This is related to the basic norms of the contract law, because this is related with the jurisdiction who will decide regarding the basic norms of the contract law. Okay, next, Naila. This is the potential issues of the irregular company contract. We can say that, of course, as per the doctrine of the autonomy of the arbitration clause, that the arbitration agreement actually is additional agreement. So they are separated, but we are coming to the basic norms of the contract law, which is related to the void and voidable, which infringe the prevailing laws and regulations. For instance, in Indonesia, very different legal system regarding these irregular company contracts. Avoidable and void contracts means the contracts never came into existence. Can we imagine if the arbitration forum is settling an agreement that actually never exists? Can we use this? That's the issue of the void and or voidable to intervene the district court in Jakarta not to enforce the arbitral award? Yes, of course. Even though just the administrative process, administrative issue like the address of the arbiters, like the arbitration value, there's a typo, they can grant and give and they will receive the applications of the losing party to cancel or to not to issue the executor order to the winning party. And this is a potential issue. Void and voidable contracts are related to the basic norms of the contract law. Yes, many experts and literature challenge the jurisdiction of arbiter to decide the issues of void and voidable contracts. There are so many pros and cons for sure, but the basic norms of contract law actually never been settled in this era, and I think this is very crucial to be settled among the international arbitration community. Basic norms of the contract law shall be decided by the judges in the court. That some experts say. If the contract is not void, or it means that it's still valid, then dispute examination in the arbitration shall continue. But if the contract is null and void, then the arbitration process still continue. If the contract is null and void, then the arbitration process still continue, but limited to announce to the disputing parties that the contract never came into existence. So this is pros and cons among the experts. So many literatures already discuss about this issue. This is not the substance of the contract. This is the basic norms of the contract law. And also some issue that usually happen in Indonesia, for instance, the principle of ex aequo et bono. This is actually globally or widely recognized that the ex aequo et bono shall be agreed by the contracting parties, must be stated in written in the agreement of the parties. But sometimes what happened in Indonesia, for instance, in the domestic arbitration process, that sometimes they decide a dispute based on the ex aequo et bono, based on the fairness of the arbiters. For instance, there's there's a dispute in arbitration. For instance, in the domestic arbitration in Indonesia, company A and company B. In the contract, it already said if one of the party is in default, they must pay a penalty, for instance, 5% of the contract value. That's the penalty, or maybe we call it for the construction project liquidated damages. But once it is being examined in the arbitration process, the arbiter says this shall not be given. This penalty shall not be given to the winning party. For what basis? This is for the fairness basis. Actually, this is ex aequo et bono. We never, the both parties didn't put or didn't agree in the contract that the arbiter has the authority to decide based on the ex aequo et bono. But in reality, when the arbiters decide the case on basis of ex aequo et bono, we can say this is also one potential issue that we can that one of the party, especially the losing party, to file a request to the district court that what arbiters have done is using the authority of the judges. Should be the arbiters should be limited. The authority of the arbiter should be limited only to the substance of the contract and also in accordance with the law. The authority to decide cases, to decide dispute based on the ex aequo et bono in Indonesian law is under court, not under arbitration process. So this is also potential issue because there are so many decisions actually arbitration process in Indonesia, arbitral award that has been awarded based on this ex aequo et bono. And this is potential issue to cancel or to revoke the arbitration award or the arbitral award. And the winning party will have a problem in the future. Okay, next. Okay, in conclusion, I can sum up. There are some points that need to be taken into account. For instance, registration and executor order or stipulation of enforcement are required to enforce and foreign arbitral award in Indonesia. An international foreign or the arbitral, an international or the foreign arbitral award is enforced under an executor order by the District Court of Central Jakarta. Here it is. If the assets to be executed located outside Central Jakarta, the executor order shall be delegated to the competent district court of the assets. Because we are so many islands in Indonesia, so many provincial, so sometimes the location of the assets can be spread not only in Jakarta but in other city in Indonesia. So we need two district courts involvement in this case. The first is as the gate is the District Court of Central Jakarta to issue this executor order, and then the involvement of the competent district court where the assets located. And the District Court of Central Jakarta may issue a non-executor order to the foreign arbitral award if the arbitral award infringes the public policy or public order, as we say, as we already discussed in the previous slide. For instance, this irregular company contract. Formalities issues and also technical issues can be the reasons for the losing party to intervene, and the reason for the district court not to issue the executor order. However, a cassation appeal of a non-executor order can be submitted to the Supreme Court, so it's not a final and binding. The disputing parties are not allowed to directly intervene in the enforcement process of the District Court of Central Jakarta. So sometimes how to intervene just by request or objections by the disputing party can be filed by a letter to the District Court of Jakarta, of Central Jakarta, not directly involved in the process of the enforcement. And last but not least, the choice of law is very important to avoid the irregular company contract issue. It is commonly caused by the distinction of legal systems among the contracting parties and the unawareness as well as unknowingness of the issues of contract law and or company law or its counterpart jurisdictions. So this is very common that sometimes the international contract, even the party are both of them are Indonesian companies, but they choose, for instance, governing law, English law, for instance, and then the seat of arbitrations is outside of Jakarta. That's very common in Indonesia. But actually, the contracting parties actually are both Indonesian companies. So if they want to draft contract or execute a contract, the choice of law is very important. And once Hence, a relevant lawyer is crucially needed in reviewing or drafting a company contract. This is for sure. This is to avoid any potential issue as we've been discussed regarding the problem of the irregular company contract. Yeah, I think that's all. Thank you very much for the time. And hopefully I already shared some valuable thoughts and informations. But if there's a questions, feel free. We need to discuss further. Thank you very much and good afternoon.
Thank you, Mr. Jeffrey. The presentation was indeed very captivating. As to quote Mr. Jeffrey's statement that the most important from the dispute resolution is not the arbitration, however, the enforcement of the award itself, and therefore we would like to thank for the amazing and captivating presentation that was done by Mr. Jeffrey. Before we continuing to Mr. Jeffrey question, we would like to submit 2 questions for Mr. Ricardo Gonzalez from Honduras. First, the question is from Fika from Indonesia to Ricardo from Honduras. What legislation governs the enforcement of arbitration proceeding in your jurisdiction? Is there any impact since this pandemic started? And how the enforcement in Honduras to set aside the awards in Supreme Courts in your country? Thank you.
All right, thank you for that, Naila, and thank you, Fika, for submitting that question. As I mentioned before, in first place, we have a pyramid of relevance in regards to how we perceive our laws. So we got the Constitution right next to the international treaties and conventions. At this point, it's the highest degree of importance to respect the New York Convention to which we are subscribed to. So that would be the governing legislation. However, we have our own legislation that I showcased during the presentation, in which we have the conciliation and arbitration clause, conciliation arbitration law, and the civil procedure code. Those 3 are the governing laws in arbitration in my country, with that level of importance. To address the second question in regards of if the pandemic has any impact, yes, it has. Honduras, because of how small the country is and how conflicted it can become, we have surely had a lot of litigations and a depth in judicial proceedings. Hence, we have our courts packed with cases that are being solved through the traditional medium of going to court in the country. So since the pandemic started, that just got worse, because then we were not prepared to host any sort of virtual or digital platform in which people could actually submit claims or submit any arbitral award, either domestic or international, to be enforced in the country. So that basically set back a lot most of those enforcements of awards, and basically courts started working back again at less than 50% capacity around August last year, and they probably have not catch up with all the cases since arbitration is mostly a private matter and we are still a bit new, like barely 20 years in developing arbitration in the country. We have had that issue in which we still don't have all the data to analyze. But the impact in general was to the court level, in which they were not operating at full capacity, in which that would create a delay in the enforceability of arbitration awards, either domestic or international. And in regards to the set-aside rules, Article 74 of the Conciliation and Arbitration Clause established around 9 different reasons for which one person could set aside an arbitration award. Whichever party who's not satisfied with that arbitration award would have around 7 days tops after being notified about the arbitration award to file a set-aside claim in which they would require the the court to set aside that arbitration. For instance, that could be that the object of the arbitration award is something that is considered illegal in the country, or any other illegal activity or something that is considered illegal in the country. For instance, also if the arbitration tribunal was not made according to the arbitration clause or the arbitration procedure, and there might have been a bias in one of the arbitrators, that could be a reason to set aside. If there was no notification made according to the law in regard of the act of going to arbitration, and the person who was supposed to go to arbitration never knew about the arbitration going on, that's also grounds for a set aside. Also, like if there were not sufficed proof that were provided during the arbitration. So if, for any instance, we use our public resources, such as the court investigation units and all that, to create proof for the arbitrations, if for some reason there was not enough time, or they just simply not process the proof that was created by one of the parties, that's also grounds for set aside. If for some reason the arbitration procedure did not have a clear timeline in which it should have ended, that would also be set aside. If also the ruling was not made in base of rights or justice, and there was any circumstance in which the award seems to be one-sided and not fair, that could be grounds for set aside. I'm sorry that I'm going too slow with this. It's just a few reasons of why there could be a set aside. Also, if for some reason in the arbitration award, the price of the award was not set properly, there might have been an arithmetic error, maybe a typo on one of the numbers for the arbitration price, and that could be a grounds for set aside. You wouldn't want to give less or more money to the party who's getting the benefit out of the award. And also, if for some reason there were inconsistencies during the arbitration procedure that might make it seem as an unfair trial, would be reasons for a set aside. I hope that answers those questions.
Yes, thank you very much, Mr. Ricardo. And the next question is from Lucky Masriansha. Why the arbitration law is based on the model United Nations UN Arbitral and involves the modernization of the Honduran law on conflict resolution? Thank you.
Right. Thank you for that, Ayla. And thank you for that, Lucky. So, as I mentioned before, we used to have a procedures code dated from 1906. That's way back in the past, and we used that one up to until 2006, which is a long time to not really have any set rules for arbitration procedures to be handled in the country. There were mentions about alternative method dispute resolution, such as conciliation and mediation, but not arbitration concretely, which means that arbitration was not a way in which we could just solve any conflicts arising from a contract in which there's an arbitration clause, precisely because in Honduras, there was no practice of having arbitration clauses back then. Once we started creating this whole schematic for having arbitration procedures in Honduras, that's when we became aware that we needed a set of rules that could be widely accepted across the globe for us to implement in our own country. Kind of goes with the saying of if it's not broken, don't fix it. We turned into the UNCITRAL rules of the United Nations because those were model rules that were accepted across the world and that could be replicated in our country. And that basically helped us place ourselves as a country that was amicable, not only for an arbitral award of enforceability, but to actually conduct arbitrations inside our territory. So by using UNCITRAL rules, despite them being quite old at the time, that allowed us to give a step forward into providing services in arbitration that could surely be interpreted by any other foreign attorney who's looking into our arbitration law. So in that sense, Honduras has progressively worked towards the modernization of an arbitration process. And this is due to the fact of what I mentioned before. Our courts are packed with cases that have a lot of time being in there. And since we have much more cases than we have judges available to resolve these conflicts, arbitration was the solution in which the country was able to take some of that load of work from the courts and made people able to actually solve their issues in a private manner that would essentially make the job of the courts easier. Because again, going through a civil claim in Honduras would take you around 2 years, up to 4 years, depending on the complexity of the case, rather than an arbitration, which would take you up to 6 months, regardless of anything. So arbitration being a private procedure handled by private parties in a private entity, because our arbitration centers are not public entities. They are basically a concession to private entities that handle these arbitration and conciliation centers. So part of that modernization was being able to create these arbitration centers that would reduce the load of our courts. And again, Arbitral rules was widely accepted across the world. And nowadays, and going back to the question about how the pandemic affected, we did not have a proper online solution for arbitration hearings to take place at, and neither did the courts. So the pandemic actually forced my country to get a little bit more into the world of globalization and started digitalizing some procedures. And in some of those cases, that meant being able to start adopting measures that across the world were already established, such as being able to file claims online, and in some cases of extreme urgency, to be able to hold any hearings digitally. The arbitration centers were not being able to do so because there were no laws that allowed for it or no internal regulations for it. But due to the pandemic, that's something that straight happened around August this year, on 2020. And as I mentioned before, Prospera's arbitration center, it's a cutting edge facility that handles electronically all arbitration hearings and all arbitration procedures. So you would never have to technically go to any arbitration hearing room or anything of that sort. You could handle that online. So by us adopting international measures and regulations, it's not that we copy pasted the arbitral rules into our own rules. We basically use them as an example that we later adopted into what is commonly used in the civil law country that we are. And that way, it provided us the pathway into creating a more technologically advanced and modern system, not only for arbitration, but for judicial claims as well. So I hope that answers those questions. I appreciate them. I think they are pretty good questions, and I'm glad that you take interest in my country's procedures. Thank you, Naila.
Thank you very much, Mr. Ricardo. It was a very amusing matter regarding the ancestral model law that is applied in Honduras. Moving on to another question, we have an inquiry from Mr. Taruna to Ms. Irina. Are there any subject matters that may not be referred to arbitration under the governing law of Russia jurisdiction? Ms. Irina, if you would like to answer the inquiry.
Yes, Naila, could you please repeat the question?
Sure, Ms. Irina. This is an inquiry from Taruna. Are there any subject matters that may not be referred to arbitration under the governing law of Russia jurisdiction?
Yes, what about subject matter? As I told in my speech, there are some rules in Russian legislation which prohibit some of the kind of disputes from
Due to the connection, maybe Ms. Irina will not be able to proceed the answer for the inquiry. Now we would like to moving on to the question and answer session. If there are any of the participants that would like to inquire to any of the speakers, may please write in the comment section. Don't forget to mention your name, institution, and to whom the question will be addressed. Thank you. Okay, there is one question from Sika to Mr. Jeffrey. Why in Indonesia there are many organizations or bodies for arbitration dispute resolution institutions, even though there is already an Indonesian National Arbitration Board organization? Is it because Indonesia's reputation is not friendly for arbitration settlement compared to Singapore? Thank you, Mr. Jeffrey.
Actually, this is confusing. Actually, the question is very confusing. Actually, but the point is, our law does not prohibit for any institutions or for any parties to establish the arbitration process or the arbitration forum. The point is, the arbitration is to have an arbiter having expertise in the specific industry or in the specific cases or dispute. For instance, in capital market, we need an expertise in capital market law. If we brought this issue to this case to the BANI, maybe it's very difficult because, for instance, the BANI or the other institutions, they already have the list of the arbiters and with their own expertise. So that's why, for instance, also for the sports, they have their own arbitration body, because the list of the arbiters having the expertise in the sports law, for instance, or the sports industry, or for the property or even the oil and gas. Oil and gas also is going to establish a new arbitration body or forum in Indonesia. So it is not restricted, it's not prohibited, as long as the party agreed in the contract that they are going to settle their dispute in the arbitration forum. I think that's allowed, not prohibited in Indonesia. I think that's all, Naila.
Thank you very much, Mr. Jeffrey, for the interesting answer regarding the arbitration body in Indonesia. However, if there are no further inquiries, we would like to continue to our next agenda. As a token of our appreciation for their time and valuable contributions, may I request Mrs. Dolly, as the representative from Bursa Hukum and Bursa Legal, to kindly present a certificate to the presenting speakers. First, we have Miss Irina. Miss Dolly, if you would like to give a appreciation to the speakers.
Okay. Thank you so much, Miss Irina, for your contribution, for your valuable sharing for today, and hopefully we're looking forward very soon to have you again in our next event. Thank you so much, Miss Irina. And next, Naila.
All right, next we have Mr. Ricardo.
Mr. Ricardo Alejandro Gonzalez Alquero, thank you so much for your valuable sharing this afternoon. And hopefully all the best for you, and see you again for our next event. Thank you so much.
Thank you very much.
Welcome.
Further, we have appreciation for Miss Prita.
Rita Amalia, thank you so much. We are so glad to have you here, or your valuable sharing, the valuable thoughts, the experiences. Thank you so much. We are looking forward to have you again in our next event. Thank you so much.
Thank you. Thank you, Madoli. Looking forward to have a collaboration with you again. Thank you.
Next, since Miss Irina earlier have a connection issue, we would like to again appreciate Miss Irina for becoming the speaker in our event. Miss Irina and Miss Dolly.
Yes, I'm so sorry that I was disconnected. I had core experience as told. If you have further questions which you didn't answer, please connect me. I think that Nahila has my my mail, or you can find it on my presentation. I'm so sorry that I couldn't fully participate, but I'm really glad for your invitation and for this event. I'm really looking forward to have more events, such kind of events. And thank you so much, and hope that maybe next year the situation with COVID-19 will be better, and I could travel visit Indonesia.
We will be so glad to have you here. You're so welcome. So
Yes,
many
thank
interesting
you.
things that we can do together, that we can deliver together, hopefully. Thank you so much.
Yeah, thank you. For Russians, especially Indonesia, it's a really popular place for vacations, and a lot of friends, my friends now spending in Bali. So I will be really happy to go with Indonesia and Bali too.
You're so welcome. Back to you, Naila.
Thank you, and last but not least, to Mr. Jeffrey.
Yes, and for the next, thank you so much, Mr. Jeffrey Santoso from LDM Lawyers, for your valuable sharing knowledge this afternoon. We wish all the best for you, success for you, and we will have you here in our next event very soon. Thank you so much.
You're welcome, Miss Dolly and Bursa Hukum and team. Thank you very much for your time and also all the efforts. Very interesting webinar session.
Thank you. And moving on to the announcement of today's best participants, we would like to congratulate to Mr. Gary Gumelar Pratama SHMH and to Mr. Gary Gumelar Pratama SHMH as the best participant of this event. And further, we would like to also congratulate Mr. Amarullah Surbakti as the best participant of today's event. And next, we will have the photo session with all of the participants. All of the participants may please turn the video on.
Okay, please let us know if it's already on. You already click it, Naila. Okay.
Okay, 3, 2, 1, say cheese. Lagi. Another one. 3, 2, 1, say cheese. Thank you so much. On behalf of the organizing committee of today's event, we would like to thank all of the participants and the presenters for today's event. Hopefully, this event will be beneficial towards all of us. Thank you and have a lovely day.
Thank you.
Thank you, everyone. Thank you.
Thank you, everyone.
Have a great day, everyone. Thank you.
Thank you. Have a good day.
Thank you, Naila. Mbak Deli, terima kasih.
Thank you.
Pak Jeffrey.
Terima kasih Bu Prita.